Please be seated. Good afternoon. Are you juror 18?
Yes, I am.
All right, now allow the attorneys to begin their questions.
Good afternoon. I'm Sarah Miller, and this is Andreas Gardner, and we're here on behalf of the state of Florida. Prior to coming in this morning, had you heard anything about the case?
Yes.
And where did you hear information?
From the news channels.
Did you see a lot of news coverage or a little news coverage?
Just a little.
Now, the state of Florida is obligated to prove the charges beyond a reasonable doubt, and we can only do that through evidence that comes in this courtroom. We can't obviously control what the news says or does. What you hear may or may not be factual. It may or may not come into evidence. Would you be able to put aside what you've heard or seen on the news and listen only to the evidence that comes into this courtroom?
Yes.
Now, we expect that this trial will be an additional 2 weeks. We think it's 2 to 3 weeks total, and we're in our first week. Do you have any particular hardship or issues sitting here for the next several weeks?
Yes.
And what is that?
It would be medical.
Okay.
I have 2 pending doctor's appointments scheduled for next week. They are diagnostic.
Okay.
So I don't know the status of my health would be able to go through 3 weeks.
Sure. And I assume getting those appointments is difficult to do.
Yes.
And if you had to cancel those or reschedule, would that weigh on your mind, your health issues, and make it difficult for you to focus on this trial?
Yes.
All right. Thank you very much.
I have no question.
All right, ma'am. Your jury service for the year is complete and you are excused. Thank you.
Thank you.
All right, no objection then to juror 18 stricken for cause. 269. All right, please be seated. Good afternoon. Are you juror 269? All right, then I'll allow the attorneys to begin their questions.
Good afternoon. I'm Sarah Miller, and this is Andreas Gardner, and we're here on behalf of the state of Florida. Prior to coming in this morning, did you hear anything or see anything or know anything about this case?
No.
Now, the judge mentioned this is a 2 to 3 week trial. We're in our first week, so we anticipate another 2 weeks. Do you have anything coming up in the next 2 weeks that would create a hardship for you to be a juror in this case?
No.
Now, you heard that this case is unique in that we are seeking the death penalty. Typically, in a normal trial, jurors get to go home after the verdict. But in this case, if you find that the state proves a charge of first-degree murder beyond a reasonable doubt, you will be required to stay and make a recommendation as to the sentence. And the only 2 options are either the death penalty or life in prison. And life means life now in Florida. There's no parole. Do you have any personal or religious or moral objections to the death penalty?
I do not. No.
Now, I would like to just know a little bit more about where you may fall with your views. Some people have strong views. Some people have more neutral views. There's people way over here that say any premeditated murder, that person should get the death penalty, regardless of who it was they killed or what the circumstances were. And then there's people on the other side that say that no one should ever get the death penalty, no matter who they killed, how many people they killed. And then you have people in the middle that would say it really should be a case-by-case basis, and it should be based on what the facts are. Where would you say you fall in that spectrum?
Very much in the middle. I think that it should be a case-by-case basis, that everyone deserves a chance to have their story told.
Okay. Now, in the state of Florida, there are only limited times we're even allowed to seek the death penalty. And the law makes it very clear that there has to be certain aggravating factors. And the state has to list out those aggravating factors. And then it's our burden to prove an aggravator beyond a reasonable doubt. So if you get to the penalty phase as jurors, you'll hear us present evidence as to why we believe this case is aggravated and why we believe the defendant should get the death penalty in this case. And you'll be able to consider evidence you hear at the penalty phase. You'll be able to consider and rely on evidence you heard in the guilt phase. You'll also get a chance to hear from the defense if they choose to present mitigation. They have the opportunity to present any kind of evidence regarding the defendant's childhood, mental health, or whatever they think would be something that you as jurors should know. And then after that, you all have to individually decide what do we recommend? And if you've all found that the state has proven an aggravating factor beyond a reasonable doubt, then you need to each make a recommendation. Do you believe that after hearing everything, if you felt that the facts and circumstances did warrant the death penalty, that you would be able to actually look and tell the judge, I would recommend a death sentence in this case?
I've never put myself in that position before.
Right.
I think it's a very heavy thing to be in that position, but I do feel like I could be unbiased and make a decision.
And that's what we would ask. We realize that this is a huge decision that most people never have to make. It's a huge ask from us to ask you to make that kind of decision, and we recognize that and respect that. Would you also then, on the flip side of that, if you felt that the facts and circumstances weren't deserving of a death sentence, would you feel comfortable then telling the judge that I recommend a life sentence?
Yes.
Now, there needs to be 8 jurors to recommend death in order for the defendant to be sentenced to death. If it's anything less, then the defendant will get a life sentence. If the vote were split, where you had 7 people that were recommending death and you were the last one to decide, no pressure, right? Do you think that you could still make that decision and stick to what your beliefs were, regardless of which way that may tip the scales, whether it tips it toward life or tips it toward death?
Absolutely.
Thank you very much for your time.
All right, Mr. Shirley.
Good afternoon.
Hello.
Kevin Shirley and Lee Hollander on behalf of Mr. Wilson. I think I understand your position. Fortunately, most people have not been in the position that you may be in or will ever have to be in the position that you may be in, and it's not a comfortable position. Unfortunately, or fortunately, you live in the United States and you live in the state of Florida, and since we have that possible penalty, you need to do your duty as a juror, and here we are. Have you really thought about that penalty in the past at all?
I have thought about it in watching, cases, whether it's right for us to make that decision or not, but I haven't spent a lot of time putting myself in that position to make that
Now,
decision.
since you mentioned that, obviously, there are other decisions that have come out there that we can't ignore that are in the news. You understand we have to put anything that we've read or heard about any other decisions aside, concentrate on the law and the facts and the arguments that you're going to hear in this particular case, whether you agree or disagree with the other findings. You weren't a juror in those causes and you have no idea what those folks went through.
Absolutely.
Okay. So you'd be able to focus just on this case and not concern yourself with any of those other cases you may have read about or heard about.
Yes.
Obviously, by virtue of the fact that you have seen things or read things out there, you understand that this penalty is reserved for the worst of the worst homicide cases. Yes,
Yes,
not
correct.
just homicide case. Well, the only way you can impose the death penalty in the state of Florida is on a homicide case, but it's not all homicide cases. It's not even most. I mean, most cases are life. Almost all cases are life. It's that those very few special cases where you're allowed to consider the death penalty. Do you understand?
Yes. I do now. I did not realize that.
I'm sorry, what?
I did not realize that. I
Oh.
understand that now.
And the state has alluded to this in their discussions with you. In order for the state, I mean, you go through the guilt phase. We're presuming in our arguments to you or our discussions with you this afternoon that the jury has already returned a verdict of guilty on at least one homicide count. But in all candor, you haven't heard any facts and circumstances. Nobody's rendered a verdict. But for purposes of our discussion, we have to assume that the jury has rendered a verdict of guilty on at least one homicide count. Do you understand?
Yes.
Now, in order for the state to jump it up to that level where the jury can consider whether or not it's a case where death could be a possible penalty, they have to prove these aggravating factors beyond every reasonable doubt. We can't tell you what the aggravating factors are. We have to reach that point. If the jury finds Mr. Wilson not guilty or guilty of lesser charges, you never get to that point. It's only after the jury has rendered a verdict of guilty. Then the court will instruct you as to what the aggravating factors are. There's just a few of them, but nevertheless, you have to consider them because they're part of the instructions to you. Then you have to go back and determine whether or not the state has proven them beyond every reasonable doubt. The state can rely on evidence that's come out during the course of the trial. The state can put on additional testimony or other evidence that you could consider in determining whether or not it has risen to that level. But nevertheless, you're going to have to go back there, and you as a jury are going to have to determine that the state has proven at least one aggravating factor beyond every reasonable doubt. If all 12 of you don't agree on that, then you have to return a recommendation of life. Do you understand?
I thought she said it was 8 jury.
No. That's the end proceeding.
Gotcha. Okay.
Okay. Before you even get to that last vote, okay, you as a jury need to go back there and determine whether or not, and it may all be this part of the same seating and deliberation process, but the first discussion you have to have when you go back to that jury room is, have they proven any of the aggravating factors beyond every reasonable doubt? Do you understand?
Yes.
That's the first vote you would take.
Yes.
And if it's not unanimous, then you're done. And come back and you have to recommend life in prison. Do you understand?
Yes.
I'm glad we had that discussion. Then you may have to go on and consider in your own mind whether or not the mitigating circumstances that are to be argued to you, the judge may tell you, instruct you on some mitigating circumstances you can consider. That's not the only list. There might be something you heard during the trial that you think is a mitigating circumstance. We may put on testimony of witnesses that will tell you about Wade Wilson when he was a kid, or his mental health, all these other kinds of things that you can take into consideration that I can't tell you about now. But there are things that you can take into consideration that we call mitigating circumstances. The mitigating circumstances are designed to erode away the aggravating factor. And if it erodes it away to the point where the mitigating circumstance outweighs the aggravating factor, once again, you're done. Okay? And the jury comes back with a recommendation of life. If the aggravating factor still outweighs the mitigating circumstance, that doesn't mean that you come back automatically with a recommendation of death. At that point in time, you get to self-reflect. You get to decide, this is my decision. We're all going to have to live with this decision. Is this the appropriate decision based on the facts and the circumstances and the law and just the type of person I am? My life experiences, everything come into play in that last decision. And that's when you go into the 8-4. Do you understand?
Yes.
And I think you've already told us that you believe you're up to that task.
I do.
I don't have any further questions. Thank you, ma'am.
Any objections?
No objection, I'm sorry.
That's okay. All right then. So you remember my earlier instructions about doing any research, looking up anything, don't watch any local news channels or read any local newspapers. Can you adhere to all those instructions?
Yes, I don't even watch the news now, so.
Okay. And don't discuss this case with anybody else, even close family members or anybody else. You understand that?
Yes, sir.
Okay. Then please follow those instructions and join us tomorrow morning at 9 a.m. You'll meet down in the jury room on the second floor where you first started.
Okay.
All right. Thank you. Should be 237.
Your entry.
All right. Please be seated. And are you juror 237? All right. Then the attorneys may begin their questions.
Good afternoon. Good afternoon. Almost good evening. Not quite. I'm Sarah Miller, and this is Andreas Gardner, and we're both here on behalf of the state. Prior to coming in this morning, had you heard anything about this case?
I have not known.
Now, you also heard that the case is going to be 2 to 3 weeks. We anticipate another 2 weeks beyond this week. Do you have any hardships or any reason as to why you could not serve?
Not that I can immediately think of.
Now, you heard this case is different and that it is a death penalty case, which is very unusual. Normally, after a state proves the charges beyond a reasonable doubt, the jurors go home and the judge does the sentencing. But in this case, if we prove at least one count of first-degree murder beyond a reasonable doubt, the jurors won't go home. The jurors will actually come back for a penalty phase in which you will actually have to make a recommendation of either life in prison, which means day for day, life is life, or a recommendation of the death penalty. Now, do you have any religious or moral views in opposition to the death penalty?
No.
Now, people often fall on somewhat of a spectrum when it comes to the death penalty. There's people that are on one side that say if it's premeditated murder, they should be put to death, no matter what the circumstances, no matter what the case. And then you have people on the other side that would say we never should have the death penalty. It doesn't matter if there's 5 people killed, 2 people killed, doesn't matter what the facts are, we shouldn't have the death penalty. And then you have people that are in the middle that would say it really depends on the case. I'd want to know the facts, I'd want to know the circumstances, I'd want to really listen to the evidence and make a decision based on what I heard. That it's death penalty is not for every case. How would you say, where would you say you fall on that spectrum?
Somewhere in the middle.
Now, at that penalty phase, you will have to decide if the state proves an aggravating factor. And the law doesn't allow the state of Florida prosecutors to be over on this side with regards to the death penalty. There are very specific factors that have to be met for the state to even file a notice seeking death. And so in this case, the state did file a notice seeking death and did list aggravating factors that we believe make this case rise to the level of a death penalty case. And because of that, it's our burden to prove at least one of those aggravating factors to all of the jurors. So at that penalty phase, if all of the jurors find that we proved one of those factors beyond a reasonable doubt, then it will be up to each individual juror to decide which sentence to recommend. The defense will have the opportunity at that penalty hearing to present mitigating circumstances, to present evidence or information before you to allow you to know other things about their client that may influence you to vote for a sentence of life instead of death. And you'll get to consider everything. You'll get to decide what weight to give everything. You'll decide what facts maybe in the trial are important to you, what facts influence you. That's completely up to you and you alone. Now, in order for the defendant to be sentenced to death, at least 8 jurors have to agree to that recommendation. If 8 jurors don't agree to that, then he's sentenced to life. Now, if 8 jurors or more recommend death, then that will be the recommendation to the court, who ultimately sentences the defendant. Now, if you felt that after hearing the trial, after hearing the penalty phase, if you felt that those factors really did rise to the level of a death sentence, would you be able to sign your name and make that recommendation to the court?
If I felt that, yes.
Okay. And then on the flip side, if you felt that it just didn't really rise to the level of the death penalty, that you felt like a life sentence was more appropriate, would you feel comfortable making that recommendation?
Yes.
Now, as I just mentioned, there have to be 8 people. So if you got back there and there was a split and 7 people were recommending death and your vote was the one that would either go life or death, would you be able to stick to what you thought and your idea about the case and make a recommendation based on your own beliefs?
Yes.
All right. Thank you very much for your time.
Mr. Shirley.
Good afternoon.
Good afternoon.
Kevin Shirley, together with Lee Hollander on behalf of Mr. Wilson. Thank you for your patience. I just want to get into a little bit more specific. Do you understand life in Florida is life? If the judge imposes life upon Mr. Wilson, he goes to prison. They shut the doors. He never comes out again. He's never in society again. He's in prison.
Yes.
We did away with parole years ago, so there's no form for him to release anymore. He has to stay in prison until he dies. Understand?
Yes.
The process. Some of the jurors, I'm not quite sure that they understood. In the state of Florida, there's only 2 possible penalties for homicide, either life in prison or death. But most of them most of these homicides are life homicides. They don't rise to the level of the death penalty. Do you understand that?
Yes.
It has to be an exceptional circumstance in order for it to rise to your consideration of the death penalty as one of the two possible penalties. You understand?
Yes.
In this particular case, the judge would instruct you regarding a term called aggravating factors. The state has to prove one of those aggravating factors beyond every reasonable doubt. If they do not prove at least one beyond every reasonable doubt, then this case has not risen to the level of your consideration of the death penalty, and you have to return a recommendation of life. You understand?
Yes.
In order to get to that point, the state would provide evidence, they would provide argument. Maybe they would want you to consider some of the evidence that came forward during the guilt phase of the trial, some of that evidence. But they would turn to you when you go back to deliberate, and the first thing you would have to do is determine whether or not the state had proven at least one of the aggravating factors beyond and to the exclusion of every reasonable doubt. If they have not proven it to all 12 folks, even one holdout that says, no, I don't think they proved it, then you have to return a recommendation of life. You understand?
Yes.
In order for you to recommend death, you have to go through several steps because it is a very, very unusual sentence. You understand?
Yes.
You would also be able to consider, before your final deliberation, what they call mitigating circumstances. The mitigating circumstances only need to be proven by the greater weight of the evidence, not beyond a reasonable doubt. Beyond a reasonable doubt is a very high standard. It's the same high standard that was required in the guilt phase of the trial. Do you understand the difference between the two burdens of proof?
Yes.
So if the defense is able to show you sufficient mitigating circumstances that erode the aggravating factors down to the point where the mitigating circumstances outweigh the aggravating factors, then you have the duty to return a recommendation of life. You understand that?
I do.
If, for whatever reason, the aggravating factors still weigh a little bit more than the mitigating circumstances, then you have to go back and make that personal decision as to whether or not you feel this is the type of case that you would recommend the death penalty. Merely because the state has still been able to maintain their aggravating factors does not mean you automatically come back with a recommendation of death. It's still a very personal decision as to whether or not this case is so extraordinary that you are willing to recommend to this judge to sentence Mr. Wilson to death. You understand that?
I do.
Do you think you're capable of doing that?
If needed, yes.
I don't have any further questions.
All right. You remember my instructions about not doing any research, looking up anything, or talking about anything about this case with anyone. Also, not watching any local news channels or looking at any local newspapers or other periodicals. You understand that? Can you follow those instructions?
I can.
All right. Then please come back tomorrow morning at 9 a.m. and meet in the jury room downstairs on the second floor. Okay.
Prove one of those aggravating factors beyond a reasonable doubt. If the jurors unanimously find that, then that's when you get to make a recommendation of either life or death. And during that penalty phase, the defense can present mitigating circumstances. So they can give whatever reasons that they have or feel that the jurors should consider as to why their client should not get the death penalty. And then again, we'll present evidence as to why we believe this case does rise to that level of the death penalty. We recognize that asking jurors to make that kind of a recommendation is not an easy one. No one really probably wakes up and thinks, gee, I want to make that decision. But that is where the state of the law is in Florida, and that's what we will be asking you to do. Do you think that if you find the state has met that burden and that you feel that the facts and circumstances warrant the death penalty, that you would be able to make that recommendation?
With those factors being true, yes.
Okay. And then on the flip side, if you felt that the factors just really weren't strong enough, or you didn't think that they really rose to that level where the death penalty should be recommended, would you feel comfortable in making the recommendation of life?
Yes.
Now, you seem like someone who's thoughtful. You thought about this today, about what you think about the death penalty. If you were to get back in that jury room and the vote was split, there has to be at least 8 people to recommend the death penalty. And if there was 7 who had recommended it, and your vote was a deciding vote, and your vote would either be a recommendation of death or life, would you be able to stick to what you believe and what you thought about the case in making your recommendation?
Yes, because I don't see that single vote as being a deciding vote, because there would be 7 others that made that decision as well.
Exactly. That's a very good point. So do you feel that this is something that you could do, that you could serve on this case and you can make a decision based on the law and the facts?
I could.
Thank you very much for your time.
Mr. Shirley?
Good afternoon, Kevin Shirley, together with Lee Hollander, on behalf of Mr. Wilson. The last thing you said is very true. There are 7 other people that decided the same thing as you. If you flip that, though, there are 4 other people that made the same decision as you. You understand? You may have been one of the. It may be a 7-5 vote, and you maybe one of the 5 as opposed to one of the 8.
Right, but that's, to me, that's immaterial. It's about my understanding of the case and what was presented, and then whatever. Like, to me, it doesn't matter.
And the only point I was making was you were presuming to be one of the 8 as opposed to one of the 5.
Understood.
Okay. The state of Florida did away with parole many years ago. If the judge sentences Mr. Wilson to life, that's exactly what he gets. He doesn't get any consideration. He gets sent to prison. They shut the doors. He never comes out again. He stays there for the rest of his life. Do you understand that?
I do.
The death penalty is reserved for those rare homicide cases that may deserve consideration of a jury to determine whether or not death is an appropriate penalty for consideration. Do you understand?
I do.
It's not in all homicide cases. It's not on half the homicide cases. It's on rare homicide cases. Do you understand?
Yes.
And that's why the state has to prove their aggravating factors beyond every reasonable doubt. You understand that?
I do.
And you as a juror, when you go back to do your deliberations, first thing you have to do is sit there and decide whether or not they have proven their aggravating factors to the satisfaction of the entire jury panel. If there's one person out of 12 that says, I don't believe they have proven one aggravating factor beyond every reasonable doubt, then you guys are done. Then you come back with a recommendation of life. Do you understand that?
I do.
If, however, you vote and all 12 of you decide there's at least one aggravating factor, then you have to sit and decide about mitigating circumstances. But the mitigating circumstances, you don't have to find that unanimously or even as a majority of the panel. That's an individual decision, an individual weighing process you have to go through. Do you understand?
I do.
So if you have an aggravating factor here, you have mitigating circumstances, you have to give whatever weight you feel the aggravating factors and the mitigating circumstances. And if the mitigating circumstances outweigh the aggravating factors, then the recommendation is for life. Do you understand?
I do.
Now, the mitigating circumstances, they come from many different sources. The judge may read you types of mitigating circumstances that you can apply. You may see mitigating circumstances that came out during the course of the trial and testimony, or mitigating circumstances that we may decide to present, even though Mr. Wilson doesn't have to testify at all. And you have to consider those, even things about Mr. Wilson's life, Mr. Wilson's mental health, all of those types of things. And you have to determine whether or not we've proven them and what weight you're going to give to them. Do you understand?
I do.
And even if you decide that the aggravating factor still outweighs the mitigating circumstance, the state of Florida can never compel you to return a recommendation of death for whatever reason. And you don't have to justify it to anybody. It's your own personal decision. For even if, like I said, the aggravator outweighs the mitigation circumstance, it doesn't make any difference. You have to be confident in your decision, that this is your decision, this is a decision you will live with, and it's your own individual decision as you make your vote as a panel. Do you understand that?
I do.
Okay. And you would uphold the integrity of your own individual decision, would you not?
Yes, sir.
I have no further questions.
All right, sir. So you remember my earlier instructions about not doing anything in terms of looking up anything, watching local news, reading local newspapers, not discussing anything about this case with anyone. Remember those instructions?
Yes.
Can you follow those instructions?
Absolutely.
All right. Then we'll have you return tomorrow morning at 9 a.m. in the jury room on the second floor. All right. Thank you. Okay, so that was the last one, right? Okay. All right. So what do we want to do? We're at 50. 51. Oh, I think I've got 52, but hold on. 73. No.
We'll see how many they can start there.
I'm telling you.
Give me a figure count, please. That's what I.
All right, so I have out of the last few, let me just make sure I've got this right. Juror 173 and juror 80 were stricken for cause without objection, correct?
Right.
And then juror 388 was stricken for cause, correct? Without objection. And then that was juror 137, who will come back tomorrow. Now, I have 52. Am I wrong?
No.
52, there you go.
Oh my goodness. Okay. All right, so we have 52 then coming back tomorrow. All right. Are both parties wanting to go forward just with the 52, or did you want to try and see if we get any more? What do you want to do?
I think we should more if we can, just because stress and alternates, I think people will come back tomorrow and be able to serve.
Okay.
I don't think my stuff out. I anticipate based on our conversation, we're going to the 5 and see what we got.
Okay.
Fine with me.
All right. So bring them down.
Either 5. We can
Let's take a 5-minute recess. That's a good idea.
end up ending all.
We'll see. All right. I think they've been waiting here all day anyway, so. All right, we'll take a recess.
Fine.
Are you juror 96? All right, I'll allow the attorneys to begin questions.
Good evening. I'm Sarah Miller. This is Andreas Gardner. We're here on behalf of the state of Florida. Prior to coming in this morning, did you hear anything about this case? And you heard that this trial is expected to be 2 to 3 weeks. We are in our first week. We've been here since Monday. We anticipate another 2 weeks. Do you have anything upcoming that will cause you any issues or hardships sitting on this jury?
No, just my job. But yeah.
I'm sorry, I'm going to have you speak up louder because we can't hear you.
Just my job would be. Yeah.
And where do you work?
I work at Florida Gulf Coast University. I'm a toddler teacher there in their early learning center.
Oh, I'm sorry. A what?
A toddler teacher.
Oh, okay.
Is that for employees?
Yes.
Oh,
Yeah,
very nice.
yeah,
Okay. Now, I assume that they would accommodate you, though, if you were chosen as a juror here?
Oh, yeah.
Now, you also heard this is an unusual case and that the state is seeking the death penalty. Normally, in a regular trial, the jurors reach a verdict, and if they vote guilty, they go home and the judge gives a sentence, and the jurors don't have any say in that. However, in this case, the state is seeking death, and so the jurors will have to make a recommendation of either the death penalty or life. Do you have any personal or moral or religious opposition to the death penalty?
I can't hear you. I'm sorry.
Oh, I didn't. I'm just thinking. I don't know. I mean, yeah, that's a big thing. I don't know.
Sure.
Yeah.
Do you come in here today with any strong feelings either way?
I do not.
One of the things that I find when talking to people about the death penalty is there are people with very strong opinions either way. There are some people that would say anyone who's charged with premeditated murder should get the death penalty. If they take a life, their life should be taken. There's the opposite side of people that would say we shouldn't even have the death penalty. It's wrong. It's immoral. And no matter what somebody does, no matter how many lives they take, they should not be put to death. And then there's other people in the middle that may not have even really considered it, but they would be willing to follow the law and to listen to the evidence and to keep an open mind and want to decide based on the facts and circumstances whether to make that recommendation of death or life. Where would you say you fall on that spectrum?
Pretty far over here, but
Far over here is in opposition to the death penalty. So what will happen is it's a very strict process that's all outlined by law. You heard a lot of that law this morning. A lot of it's legal jargon that may not be you'll be explained more as we go along. But after that first phase of the trial, the state, if you find the state proved beyond a reasonable doubt at least one count of first-degree murder, will go on into the penalty phase. And at that penalty phase, it's very specific as to whether the state can even seek death. The state of Florida doesn't just allow the state to seek death anytime someone kills someone. It's reserved for egregious and homicides that have very difficult and terrible factors. There are aggravating factors that are outlined in the statute, and the state has to prove at least one aggravating factor beyond a reasonable doubt to all the jurors. And if all the jurors find the state proves that, the defense is able to present mitigating circumstances as to why the defendant should not get the death penalty. And those circumstances can be varied. And then at the end of the day, you as a juror will make your own decision as to whether to recommend death or recommend life. Now, you may hear facts in the trial that are very disturbing or egregious, and you may hear things in the penalty phase that you believe those factors combined would deserve a sentence of death. Do you believe that you would be able to make a recommendation of death if you felt those factors were met?
I feel like that would probably be hard for me.
Okay, and
Sorry, what?
I feel like that would be hard for me. Yeah.
and that's a perfectly acceptable answer. There are some people that just say that is such a big, tough decision to be able to decide whether someone should be put to death, that I just couldn't do that. Do you feel that's where you're at, that no matter what you heard, it just would be a decision that you would not be able to make?
I do. Yeah.
And based on that, do you think
I got to hear her answer. I'm sorry.
I do. Yeah.
Okay.
And based on that, do you think that a case where the death penalty is being sought would not be the right case for you to sit on?
I do. Yes.
Thank you very much.
No question.
All right. So your jury service for the year is complete and you are excused. Thank you.
Thank you.
All right. Any objections to 96 being stricken for cause?
No.
Okay. Let's bring in 58.
You're entering.
All right, please be seated. And are you juror 58?
Yes.
All right, now allow the attorneys to begin their questions.
Sounds good.
Good evening, sir.
Hello.
I'm Sarah Miller. This is Andreas Gardner. We're here on behalf of the state of Florida. Thank you for being here today, and I apologize with the late time. There's been a lot of people we've talked to, and it's a very important part of the process. Prior to today, or today, did you hear anything or learn anything about the case?
Other than what the judge had said, no.
Okay, all right. Now, you heard that this case is expected to be 2 to 3 weeks. We've been here since Monday, so we're in our first week. We probably have 2 more weeks to go. Do you have anything in the upcoming 2 weeks that would cause you any difficulty or hardship sitting here as a juror?
Based on what the judge had described as hardship earlier, I'd say no.
Okay. Obviously, it's always a hardship for somebody to sit here. It's never easy to give up that time, but I appreciate that. This case is unusual in that the state is seeking death. Normally in a regular trial, after the jury returns a guilty verdict, they get to walk out the door and go home and be about their lives. And the judge is the one that decides the sentence. But given that this is a case where the state is seeking death, there will actually be 2 parts to the trial, and it will be actually up to you to make a recommendation of death or life. Do you have any personal or religious or moral opposition to the death penalty?
No, not this time.
Now, some people are very opinionated about it. Some people are kind of neutral. A lot of people just haven't even really given a lot of thought to it. There's a group of people that would say it doesn't matter what the murder is, doesn't matter the facts, it doesn't matter the circumstances. If someone is convicted of premeditated murder, then they should be given the death penalty. Then on the opposite side are the people that say it doesn't matter if someone kills 10 kids. They should not be given the death penalty, we should have the death penalty. And then you have people more in the middle that say it's really a case-by-case basis and it should be used sparingly, and there should be only certain facts and circumstances where it would be appropriate. Where would you say on that spectrum you fall?
I'd say more the middle.
Okay.
On that one.
And the state of Florida actually isn't on this extreme, even though you may feel that it is on the news. There are very specific certain times that the state can actually even file a notice of intent to seek the death penalty. There are aggravators laid out in the statute, and in order for the state to file a notice, we have to list those aggravating factors that we believe we can prove beyond a reasonable doubt. So they're factors that take a normal murder and make it a much more egregious murder. We have given notice of factors we believe we can prove beyond a reasonable doubt. If you as a juror and that your fellow jurors find unanimously that we proved one count of first degree murder beyond a reasonable doubt, you'll go on to that penalty phase. And at that penalty phase, we will have to present evidence and we'll present those aggravating factors. And it will be our burden again to prove one of those beyond a reasonable doubt. If all 12 of you find that we proved one beyond a reasonable doubt, then each of you on your own will make an individual recommendation as to death or life. And at that penalty hearing, you'll hear evidence from the state. You can also rely on evidence you heard from the trial. The defense will also have the opportunity to present mitigating circumstances. So anything that they believe you should consider as to why their client should not get the death penalty. But at the end of the day, it really is solely your recommendation and decision. Do you believe if you hear facts or hear circumstances you believe that would warrant the death penalty, you'd be able to sign your name and make that recommendation?
Yeah, if need be.
And obviously, it's a huge ask. It's not one that we ask lightly, and it's really not a decision I've ever heard anybody want to make. But it is the law, and so that's what we are asking. Now, on the flip side, if you heard the factors and circumstances and maybe heard some of the mitigation and just felt this really isn't the case where the defendant deserves a death penalty, would you feel comfortable making that recommendation of life?
Yes.
Now, you'll hear later on that it takes 8 jurors to make a recommendation of death. If there are not at least 8 jurors, then it has to be a life sentence. Now, would you be affected by what everybody else chose to do, or do you believe you're the type of person that could stick to what it was you felt was deserving?
I could stick to what I would believe.
You seem like that type of person that you have an opinion and you could stick to that.
Yes.
All right. Thank you very much for your time. We appreciate it.
Good evening. I have just a couple questions for you, sir. You understand? Forgive me. My name is Kevin Shirley. I, along with Lee Hollander, represent Mr. Wilson over there. You understand in the state of Florida, we did away with parole years ago. So if you as a juror recommend that life in prison be the sentence imposed by the judge, that's exactly what Mr. Wilson gets.
Yes.
They put him in prison. They shut the doors. He never comes out again. He basically dies in prison. Do you understand? If we decide to prove mitigating circumstances to you, first of all, we don't have to prove anything. There isn't a shift to the burden of proof or anything like that. Burden of proof stays with the state. They have to prove their aggravating factors beyond every reasonable doubt. Only if they are able to prove at least one aggravator to all 12 of you do we even get involved in the mitigation process. Do you understand?
I do.
Is that yes?
Yes.
Okay.
Sorry.
Mr. Wilson sits over there. He doesn't have to testify during the guilt phase of this case. He doesn't have to testify during the penalty phase of this case. At no point in time can you hold that against him. Do you understand?
Sir.
And if we're able to put on evidence of Mr. Wilson's history, what it was like to be young Mr. Wilson, the things he's gone through in his life, mental health evidence, those types of things, will you consider those things in determining whether or not life or death is the appropriate penalty?
Yes, I'd consider them.
Okay. And do you understand that the law can never compel you to return a recommendation of death? That the presumption of life is always there. If the state has met its burden of proof, if they've proven to you that death is the appropriate penalty, even at that point in time, something about your background, something about your life experiences, whatever. If you don't feel comfortable recommending death, you don't have to. Do you understand?
Sir.
I don't have any further questions.
All right, sir. So please remember my instructions and follow them, that you're not to look up anything, do any research about anything regarding the case, not discuss anything about this case with anybody else, not to watch local television news, not to read any local papers. And then we will see you back here tomorrow morning at 9 a.m. Just meet in the jury room on the second floor where you first started, okay?
Okay.
All right. All right, 497.
Yeah, they are.
Your entry.
All right, please be seated. And say, are you juror 497?
Yes.
And can you hear me okay? Can you hear me okay now?
Yes.
Okay, great. I'll allow the attorneys to begin their questions.
Good evening. How are you today?
Good.
Do you need me to come closer to that or just?
I can hear you.
Great, thank you. I'm Sarah Miller. This is Andreas Gardner, and we're here on behalf of the state of Florida. Prior to coming in today, had you heard anything or seen anything or read anything about this case?
No.
And you heard that the time that we expect the trial to be is 2 to 3 weeks. We've been here since Monday, so this is week 1. We probably have 2 more weeks after this. Does that schedule pose any hardship for you?
With work, the breadwinner, so a little bit.
Okay. Where do you work?
I work for warranty department,
And
not the
will they-
annoying one.
I'm sorry, not the annoying one. I appreciate that. Is it a car warranty one?
Yeah.
Okay. And if you do not go to work, will they not pay you?
They pay for 3 days,
Okay.
and then after that, no.
Right. So based on you being the sole breadwinner, would that make it difficult for you to pay your bills if you're unable to come?
Yes, ma'am.
All right. Thank you very much.
No questions? All right. So thank you for your service. Your jury service for the year is complete and you're excused.
Thank you.
Thank you. Yeah, I'm sorry, just follow the bailiff. Yep.
Sorry, they took it over years.
Thank you.
All right. Any objection to 497 stricken for cause?
No.
Okay. Then 391.
Your entry.
All right, please be seated. And are you juror 391?
Yes.
All right, I'll allow the attorneys to begin their questions.
Good evening. I'm Sarah Miller. This is Andreas Gardner, and we're here on behalf of the state of Florida. Thank you for your service. I know it's been a very long day. Have you heard anything about this case prior to coming? And you heard that the trial is expected to be 2 to 3 weeks.
Yes.
We've been here since Monday, so this is week 1. We expect another 2 weeks. Is there anything about that time period that would pose a hardship for you? Okay. You wish it would, right? We're here on a death penalty case. We recognize that that is a big decision. It's not a case probably most people want to be a part of. Do you have any moral or religious or personal objections to the death penalty? Now, I know people have varying opinions about the death penalty. There's some people that are on one extreme that think anybody charged with premeditated murder should get the death penalty. The other extreme is people think that the death penalty should be outlawed, that we shouldn't have it available as an option regardless of what someone may have done. And then we have people more in the middle that would say it just really depends on the case. It should be a case-by-case basis, looking at the facts and circumstances. Where would you say you fall in that spectrum?
Middle.
Now, the way it will work in this case is the state will have to prove the charges beyond a reasonable doubt. And in most cases, if the state did that, the jury would get to go home and the judge would decide the sentence. But because of this case, that if you decide the state proved at least one count of first-degree murder beyond a reasonable doubt, you'll be asked to come back for the penalty phase. And at that penalty phase, the state will actually have to prove an aggravating factor. In the state of Florida, in order for the state to seek death, there's very specific factors that have to be met. It's not just a regular murder. There has to be egregiousness or certain factors that the state has to be able to meet in order to even seek the death penalty. We have outlined those factors that we believe we can prove through the course of the trial and through the penalty phase, and we will have to present those factors to you. And if the jurors all unanimously find that we've proven one of those beyond a reasonable doubt, then at that point it will be up to you individually to make a recommendation of death or life. Now, the defense at this penalty hearing also has the opportunity to present evidence. They don't have to, but they can present mitigating circumstances as to why they think their client should not get the death penalty. You'll be able to listen to all that evidence. You'll be able to consider the trial, what you heard in the trial, the facts, what the witnesses may have said, and you will then have to make a recommendation. Now, it takes 8 people to recommend the death penalty in order for the judge to impose it. If at least 8 people don't make that recommendation, the defendant is automatically sentenced to life. And life means life in Florida. There's no more parole, so it would be day for day. Now, if you got back and you were in the deliberation room and you considered the facts of this case and the evidence you heard and felt that this would be a case where the death penalty would be appropriate, do you believe you would be able to make that recommendation to the court?
After hearing the facts. Yes.
Sure. Right. And we wouldn't want you to make that recommendation now because we would want you to base it on what you heard. It wouldn't be an easy one, but it's something you believe you could do.
So.
Okay? And then on the flip side, you might hear the evidence and you might hear the facts and think, you know, this really isn't the type of murder that I personally feel deserves a death penalty. It's the type of murder that really a life sentence would be sufficient. Would you then feel comfortable making that recommendation of life?
Yes. Yes.
And do you feel that you're the type of person that, regardless of what other people may think about the facts or how they're affected by the facts, that you would be able to stick to what you felt and how you saw the evidence in making your recommendation?
Yes.
All right. Thank you very much for your time.
It's true. Thank you. Good evening.
Evening.
My name's Kevin Shirley. I, along with Mr. Hollander, represent Mr. Wilson. Okay?
Okay.
You understand in the state of Florida, there's only 2 possible penalties if you're convicted of first-degree murder, that being life in prison or the death penalty. You understand?
Yes.
In Florida, we did away with what they call parole years ago. Some inmates, if they conducted themselves appropriately, maybe advanced their education, did some other things, didn't get in trouble, they were considered eligible for parole so they could get released early. We did away with that years ago. So now, if you as a juror recommend that the judge sentence Mr. Wilson to life, that's exactly what it means. He goes into prison, they shut the doors behind him, we never see him again, he stays in prison till the day he dies. Do you understand that?
Yes.
And overall, that's the preferred sentence for first-degree murder, because only in exceptional circumstances would you ever be even permitted to consider the death penalty. You understand?
Yes.
And regardless of whether or not, after you've heard all the evidence in the penalty phase and heard the instructions and everything, and you feel that the state's proof is a little bit greater than the defense's proof, there is nothing in the law that can compel you to ever return a recommendation of death. If you just don't feel comfortable with it, if you feel more comfortable with the recommendation of life, then nobody can talk you into it. Nobody can pressure you into it. None of the instructions or the evidence or anything else can ever force you into a recommendation of death. Do you understand that?
Yes.
I don't have any further questions.
All right.
No objection.
All right, ma'am. Remember my instructions about not doing any research, looking up anything. Don't watch local news, reading local newspapers. Don't talk about this case with anyone. Can you follow those instructions?
Yes.
I saw you sign the last one, and even with close family members, they might want to ask, but you can't talk about this case with anyone. Do you understand that? Can you follow those instructions? All right. Then we'll see you tomorrow morning at 9 a.m. Come to the jury room on the second floor. Okay?
Really?
Yes. Thank you. Okay. Is that 353? Oh, wait, what did I do?
You're entering.
All right. Please be seated. And are you juror 353?
Yes, Your Honor, I am.
All right. I'll let the attorneys begin their questions.
Good evening.
Good evening.
I'm Sarah Miller. This is Andreas Gardner, and we're here on behalf of the state of Florida. Thank you for your time. I know it's been a very long day. Prior to coming in this morning, had you heard anything about this case?
No, ma'am.
And you heard that this trial is expected to be 2 to 3 weeks. We're at our first week. We started on Monday. We probably have another 2 weeks to go. Is there anything about the schedule that causes you any hardships and ability to not be able to sit here?
Only problem would be my work covers up to 3 days of paid service.
Okay. And where is it that you work?
Home tech.
All right. And if you're unable to get paid, does that cause you extreme financial hardship?
Not extreme.
Okay. Would you still be able to pay your mortgage or your rent and your bills?
Yes.
All right. So is it something you'd be willing to do if called upon to do so?
Yes.
Now, you heard that this case is unusual and that it's a death penalty case. In the state of Florida, there's only certain reasons that the state can seek death, and we actually have to allege aggravating factors. We have to list those out. We have to give the defendant notice. We can't just seek it whenever we want. It has to be in the most egregious of homicide cases.
I'm going to get everybody to speak up louder. I know it's the end of the day.
We have listed those out, and we plan on proving those beyond a reasonable doubt. Now, do you have any religious or moral or personal opposition to the death penalty?
No.
Now, some people are very opinionated about the death penalty. Some people really haven't thought about it or neutral. You have the one end of the spectrum where people would say that anybody who commits murder should be put to death. And then you have the other end that would say it doesn't matter who somebody murdered or how many people they murdered or what the facts and circumstances are, the death penalty should be illegal. And then you have people in the middle of the road that would say it should be a case-by-case basis, that there should be specific facts and circumstances that would warrant the death penalty. Where would you say you fall on that spectrum?
I would probably say neutral, and I would say it varies case by case.
Yes. Okay. And so that's what we're going to ask you to do. If you come in and you find that unanimously as a jury that the state has proven one count of first-degree murder beyond a reasonable doubt, then you will all move to the penalty phase. And in the penalty phase, it will be your job as jurors to make a recommendation of either a death sentence or a life sentence. And that life sentence is life means life in Florida. There's no parole. So those are your only two options. Now, at that penalty phase, we'll ask you to think back to the trial and to think about the circumstances and the factors surrounding the murders. We'll also present other evidence at that penalty phase to prove our aggravating factors. And if you find, again, unanimously that the state has proven one of those, then you'll get to make a recommendation. Now, the defense at that penalty hearing will also have the opportunity, if they choose, to present any mitigating circumstances. So anything that they believe would cause you to think that this should be a case where the defendant gets life. After you hear all of that, you will have your own decision to make, and it won't matter what the other jurors decide. You will have to decide, is this the type of case where the death penalty is warranted? And if you believe so, you would recommend that to the judge and you would sign your name to that decision. If you feel that that's the situation, would you be able to make that recommendation to the court?
Yes.
And vice versa. If you felt that the facts and circumstances really weren't egregious or that the factors really weren't very strong, would you be able to make that recommendation of life?
I believe so, yes.
All right. Thank you very much for your time.
Mr. Shirley.
Thank you. Good evening. My name is Kevin Shirley. That is Lee Hollander, and we represent Mr. Wilson here today. Okay. The state has already told you there's only two possible penalties in a homicide case, that being life in prison or death. Life in prison in the state of Florida, we changed it a few years back. Used to be if you went into prison, you were a good inmate, maybe you advanced your education, didn't get in any trouble, you would be considered for a thing called parole, so you could get out early. I don't know if you've ever heard of the word before.
Have.
Okay. Well, we did away with that. So now if you come back with a recommendation to the judge, say, I recommend life in prison, the judge sentences Mr. Wilson to life in prison. That's exactly what he gets. He goes in the front door, they shut the doors behind him, he never comes out, and he stays in prison until the day he dies. Do you understand?
Yes, I do.
Okay. Do you think that's a pretty serious penalty in and of itself?
I do personally believe it is serious, yes.
Okay. Now, I'm skipping because we've been here all day and you've been here all day, so I'm skipping part of the procedure here. But if we put on mitigating circumstances such as maybe some history about Mr. Wilson's life, maybe Mr. Wilson's mental health, some other things, something you may have heard during the course of the trial, will you consider that in mitigation of the state's evidence?
I will, yes. As I said before, I believe my personal belief is it varies case by case. Every case is different in my belief.
Okay, but you understand that most of the cases, not all the cases, but most of the cases, this isn't even an issue. It's just a life sentence. It's only in those rare circumstances where the state believes they have aggravating factors that you would even be permitted to consider the death penalty. You understand that?
Yes.
Now, the most important thing is when you go back there to do your final deliberation and to do your vote as to what your recommendation as a jury panel is going to be, you may be sitting there and you may go, well, I still think the aggravators outweigh the mitigators. But you know what? Something about this case just doesn't feel right for me. And I'm not going to vote death. I'm going to vote for life in prison because nobody here nor the law can ever compel you to return a recommendation of death. Do you understand?
Yes.
Okay. Unless it is within yourself overwhelming and compelling for you to come back with a recommendation of death, your recommendation would be for life. Do you understand?
I do, yes.
I don't have any further questions.
All right. So, do you remember my earlier instructions about not doing any research, looking up anything, or discussing anything about this case with anyone?
Yes, Your Honor.
All right. Can you follow all of those instructions?
Yes, Your Honor, I can.
All right. And also, I'd ask that you follow the instruction not to watch any local news media, read any local newspapers, or anything like that for the time being.
Okay.
Can you follow that instruction?
Yes, Your Honor.
Very well. Then we'll have you return tomorrow morning at 9 a.m. in the jury room downstairs on the second floor where you first started. All right. Thank you. And the bailiff will escort you out. 150.
Yes, sir.
All right. Now allow the state to begin their questions.
Good evening. I assume it was dwindling in the jury room back there.
Yeah.
That's our goal. Thank you for your time. I really appreciate your service here today. I'm Sarah Miller. This is Andreas Gardner, and we're here on behalf of the state of Florida. Prior to this morning, had you heard anything about this case?
No.
Now, you heard the judge say this is probably a 2 to 3 week trial. We've been here since Monday, so we're getting ready to end week 1. We have probably 2 more weeks after this week. Do you have any hardships or any reason why you would not be able to serve over the next several weeks?
I mean, kind of.
Okay,
I do have bills, so I do work for a reason.
of course.
So, I mean,
Most people are in that boat. Where do you
absolutely.
work?
I work for an elevator company, so I work from St. Pete to Naples.
Okay. And if you don't go to work, will you get paid?
Yeah.
All right. So based on that, if you were unable to work for the next 2 weeks, would you have a difficult time paying your bills?
Probably, most likely.
And so based on that, would it be difficult for you to sit and listen to this case and be fair and impartial?
Probably, in a way.
Okay. Thank you.
No question. All right, sir. Your jury service is complete for the year and you're excused. Thank you.
Yes, sir.
151. Any objection to 150 being stricken for cause?
No.
Thank you.
Your entry.
All right, please be seated. Are you juror 151?
I am, yes.
Then I'll allow the attorneys to begin their questions.
Good evening.
Good evening.
Thank you for your time. I know it's been a long day. I'm Sarah Miller. This is Andreas Gardner, and we're here on behalf of the state of Florida. Prior to coming in today, had you heard anything about this case?
No, I had not.
And you heard that the trial schedule is 2 to 3 weeks. We've been here since Monday, so at the end of this week, we anticipate another 2 weeks. Is there anything about that schedule that would cause you a hardship?
Yes, I have a little one at home and I need to be there for him. And my husband works out of town, so the schedule is crazy.
Yes. How old is your little one?
He's 6.
All right. So he definitely needs a caretaker to be there. So based on that, would you have a difficult time sitting on this case and giving your attention to it?
I would, absolutely.
Thank you.
No questions.
All right. So thank you for your service. Your jury service for the year is complete. You are excused.
Okay, thank you very much.
Okay. 218. Any objection to 151 being stricken for cause?
No. Your entry.
All right. Please be seated. And are you juror 218?
I am.
All right. The attorneys will begin their questions.
Good evening.
Good evening.
I'm Sarah Miller, and this is Andreas Gardner, and we're here on behalf of the state of Florida. Thank you for your time. I know it's getting late into the evening, but we do appreciate your service. Prior to coming in today, had you heard anything about this case?
No.
Now, you heard that the trial is anticipated to be 2 to 3 weeks. We're already in our first week of trial. Do you have any hardships if you were to serve as a juror over the next several weeks?
No.
Now, this case is different in that we are seeking the death penalty. In most cases, after a verdict is reached, the jurors get to go home and the judge decides the sentence. In this case, because we are seeking death penalty, if you decide as a juror and as a jury as a whole that the state has proven at least one count of first-degree premeditated murder, then you'll come back for the penalty phase. And at that phase, it will be on you to make a recommendation of either life or death. Do you have any personal or religious or moral opposition to the death penalty?
I would have to say no. I mean, I hadn't thought about it until today.
Okay.
I've never been asked that before.
Sure.
But I would say no.
Okay. Now, most people fall along a spectrum when it comes to the death penalty. There's some people that are very opinionated, and there's many people like yourself who've never thought about it or really had to think about it. And we anticipate that most of the jurors here today have never had this experience of having to sit on this type of case, and we realize it is a very big ask. There are some people that fall on one far end where they would say the death penalty should be given to anybody that commits a murder, regardless of the facts, regardless of the circumstances. Then you have the opposite end of that spectrum where people would say we shouldn't have the death penalty at all. No matter what someone does, no matter how heinous the crime, we shouldn't have it. And then you have people more in the middle that would say it really should be reserved for serious cases and a case-by-case basis. And they would want to hear the facts to be able to say, yes, that's deserving of the death penalty, or no, it's not. Where would you say on that spectrum you fall?
I would say in the center.
Now, at that penalty phase, there are certain things that the state has to prove. In order to even seek the death penalty in the state of Florida, there are aggravating factors that are laid out by statute. And we have to allege those factors. We have to give notice to the defense counsel of those factors we intend to prove. And then we have to prove at least one of those factors beyond a reasonable doubt unanimously to all of the 12 jurors. If, as a juror, if all 12 of you decide we have proven that aggravator, then it will be up to you to determine what recommendation to give. At that penalty hearing, you'll hear evidence that the state will present. You'll also be able to rely on evidence you heard through the trial, some of the facts or the circumstances that help you form your decision or your opinion as to what the defendant should get. The defense at the penalty hearing is also entitled to present mitigating circumstances. They can present any sort of thing that they believe would help you or assist you in making your decision as to whether the defendant should get life or death. At the end of all of that, you will have the ability to decide and to recommend to the court what you feel is a proper sentence. Do you feel that if after hearing all the evidence and hearing the factors presented, if you feel that it is a case that warrants a death penalty, do you believe that you'll be able to make that recommendation to the court?
I think so.
And then on the flip side, if you feel that that just really doesn't warrant the death penalty, that you just have a feeling that a life sentence is appropriate, that you will be able to make that recommendation to the court.
Yes.
Thank you very much for your time.
Mr. Shirley.
I have no question.
Okay.
No objections.
Objection.
All right. So, do you remember my instructions about not doing any research, looking up anything, or watching anything on television? Don't look at the newspapers or anything like that. Can you follow those instructions?
Yes.
All right. And don't talk to anybody about this case, even close family members. You remember that?
Yes.
Okay. And you can follow that instruction?
I believe so. Yes.
Well, I need you to follow that instruction.
Yes.
Okay. You can't talk to anybody about this case right now. Okay. So come back here tomorrow morning at 9 a.m. in the jury room on the second floor.
9 a.m.
Yes, ma'am.
Okay.
Thank you. 3:59.
Your entry.
All right, please be seated. Are you juror 359?
Yes, sir.
All right, I'll allow the attorneys to ask their questions.
Good evening, sir. How are you?
Pretty good.
Was there only one juror left?
One more left.
All right, we're getting to the end. Unfortunately, you were a number that was toward the end. Nothing to do. We don't, it's computer generated. So thank you for your time and your patience. I'm Sarah Miller. This is Andreas Gardner, and we're both here on behalf of the state of Florida. Prior to coming in today, did you know anything about this case?
No.
And you heard that the trial is expected to be 2 to 3 weeks. So we're in week 1 right now. It'll probably be additional 2 weeks. Do you have anything upcoming that would create a hardship for you to sit here and serve as a juror?
I'm the only one work.
Okay,
So 2 weeks, 3 weeks, that a little bit pressure.
sure. Where do you work, sir?
I work by the field, so
Okay,
I travel different hospital, install break fix and preventive maintenance.
all right. And if you are unable to work, will you get paid?
I have to find out because
Okay.
I don't know.
Um, is that something you could find out before tomorrow if you were asked to come back?
Yes.
Anything else besides work that would cause a potential issue for you?
No, nothing.
As you heard, this is a death penalty case. Do you have any strong religious or moral or just personal opposition to the death penalty?
I believe like that penalty is not right.
Okay.
That's all.
All right. And based on that opinion, do you think it would be difficult for you to sit on a case where the death penalty was being sought?
I think so. Yes.
And would it be hard for you to actually, do you think it would be better to be on a different type of case where you didn't have to be confronted with that decision?
Yes.
All right. Thank you.
No question.
All right, sir. Your jury service, sir. Your jury service is complete for the year, and you're excused. Thank you for your service.
Thank you.
363. Any objection to 359 being stricken for cause?
No.
Your entry.
All right, please be seated. Are you juror 363?
Yes.
All right, I'll allow the attorneys to begin their questions.
Good evening. Hi. I'm Sarah Miller. This is Andreas Gardner, and we're both here on behalf of the state of Florida. Thank you for your time. We didn't choose you last on purpose. It's just how everything gets lined up. Did you know anything about this case prior to coming today?
No.
And you heard that the trial is going to be 2 to 3 weeks. Is there anything about that schedule that would pose an extreme hardship for you?
No, like, as far as my work, I did not ask them or inquire them about what they pay for and what they don't.
Okay.
So that I don't know.
Where do you work?
The OCC.
Okay. And is that something you'd be able to find out before tomorrow if you're asked to come back?
Yeah, I could find out today, like right now if you need.
Now, you heard that this case is unique and that the state is seeking the death penalty. Do you have any moral or personal or religious objections to the death penalty? Now, some people have very strong opinions. Some people are more neutral. You have the one extreme where people would say the death penalty should be given for any first-degree murder case, no matter what the facts are, no matter what the circumstances are. You have people on the opposite end of that spectrum that would say the death penalty should never be given, that it's barbaric, and no matter what someone does, their life should not be taken. And then you have people in the middle that would say it should be reserved for the most egregious cases, and that it should be a case-by-case basis. Where would you say you fall on that spectrum?
I've never really thought about it, given it much thought, but I definitely think it should be on a case-to-case basis.
Right. And that's what we're going to ask you to do in this case, is that if you find in the guilt phase that the state proved at least one count of first-degree murder beyond a reasonable doubt, that you come back at that penalty phase and you will be making a recommendation as to a life sentence or a death sentence. And the way that happens is the state of Florida, you cannot just seek the death penalty for any case. There are certain aggravators laid out by statute, and the state has to actually allege the aggravators and give notice to the defense about what those aggravators are. And then you will have to decide whether the state proved one of those aggravators beyond a reasonable doubt. At that penalty phase, you'll be able to consider the evidence the state presents. You'll be able to consider the evidence from the trial. And then the defense will have the opportunity, if they choose, to present mitigation. And so they can present mitigating circumstances that they believe would be reasons to not seek the death to give their client life. At the end of the day, each juror makes their own recommendation. And so do you believe that if the facts rose to that level where the crime was egregious and you believe the facts warranted the death penalty, do you believe you can make that recommendation to the court?
I don't know. I honestly don't know. I don't know. If that's, if you're asking me to make that decision, I mean, that's something that really weighs hard on you.
Sure, absolutely. And we would hope that no one would take it lightly, that it would be a decision that they would wrestle with. Do you think that it's something that you'd be able to follow the law if asked to have to make that kind of decision?
Yeah, I kind of want to believe it's out of my decision making. I'm not the one making that decision. It's, as you said, like it's more of on a factual basis.
Right, right. It would be based on what you see, what you hear, what you believe from the trial. So I thank you for your time.
Shirley?
No question.
No objection.
No objection.
All right, ma'am. So your earlier, I gave you instructions about not doing any research, looking up anything, talking to anybody about the case, or watching local television, reading local newspapers. Remember those instructions?
Yes.
Can you follow all of those instructions? All right. Is that yes?
Yes.
Okay. Please follow those instructions and come back tomorrow morning at 9 a.m. Find out about your job. Okay, and be able to answer that for us tomorrow. Come back at 9 a.m. and be in the jury room on the second floor where we first started. Thank you. All right, let the record reflect that the prospective jurors left the courtroom. That is all we have. 57? I have 55.
We had 55 before we started the last one.
Yeah. All right.
57.
Okay, I'll fix it. Okay, so we'll start tomorrow morning at 9 a.m.